Hello, everyone. Am I audible? Just say yes in the chat box if I'm audible. Okay, cool. Yeah.
I can't see your chat box though.
Sir, chat box is there in the bottom line of the screen.
Well, right now I'm seeing.
So I'll be sharing the questions which will be asked by the live audiences in the quick Q&A session. So you can start with the presentation itself, and
No,
then
but
we'll.
right now I'm not seeing the same screen which you had left me on. I'm seeing a small screen just saying C in it.
Yeah. So what you can do is you can switch on your video first, sir.
Switch
You
on.
can start your video. Uh, Please adjust your screen, sir.
I'm not able to see this. I'm able to see only the small window with a C in it.
Yeah, sure. Yes, sir. Because participants have joined, so adjust the screen a bit, sir. Yeah, a bit more, sir. Tilt it a little more, sir, please. The screen. Yeah, it's good now. So can we start the session, sir?
Yes, but I
Yeah.
need to update.
So I have made you the
I need a
code.
screen share option.
It's below the screen, sir. Share screen, the green button.
Yes.
Okay, sir. Let me just give a brief. So I'll start up with the introduction, sir, and then we can go ahead with the presentation.
Yes.
Okay. So hello everyone. I'm Chandrika Lamba from Lawyers, and will be moderating today's session. I hope you all are safe and sound at your places. And I welcome you all in the in another session of #MentorHour, organized by Lawyers and Lawyers Club of India. Uh, Today we have a very special guest and honored to have you, Advocate Hara Prasanna Kar, sir, and to give you a brief about sir, that Mr. Harakar is a legal consultant and is partner at Interjuris, Advocates and Consultants, a full-service law firm providing comprehensive legal solutions in the area of corporate law, banking, security laws, contract laws, and other practice areas in both legal documentation and litigation services. The firm advises Indian and international corporate entities, PSU banks, and corporations. Advocate Hara has over 25 years of experience, including in leading MNCs, that is multinational companies, in diverse roles, and is presently a practicing lawyer in Bombay High Court, and also in DRT, DRAT, NCLT, SAT, civil courts, arbitral tribunals, etc. Mr. Hara is a science graduate, an LLP, and holds an MBA degree too. So without wasting much of the time, I would now like to share the screen with the Advocate Hara Prasanna sir, and would request him to take the session forward and brief us about all the topics. Over to you, sir.
Thank you, Chandrika. Thanks for the introduction. And also really glad to be here with all your guests and the audience right here. So without wasting time, I'm told that I only have about 30-35 minutes for my talk, and then we'll go into a Q&A, etc. So let me start straight away into the subject. The reason for choosing the subject, which you can see hopefully on the screen, impact of recent changes in IBC and regulatory provisions from a creditor's perspective, is that in the present context of the deep crisis of the corona COVID-19 pandemic, there are going to be far-reaching changes in the market, and India has geared up to it in terms of fighting it on the ground, as well as to try to recover from the effect of it on the economic front. So hence the relevance announcements made by Honorable Finance Minister as well as the RBI. So what are the changes which have been recently made due to COVID pandemic? And is it a shot in the arm for the debtors? Because most of these changes are going to help the borrowing companies. So as I said, a spate of measures released through recent announcement made by Honorable Finance Minister and RBI Governor to bolster economy, including significant measures for the MSME segment, touching IBC regulations, as well as regulation from RBI, Companies Act provisions, etc. Ordinance suspending IBC 7, 9, and 10, Section 7, 9, and 10 for 1 year, which have been brought in to give the relief to debtors to recover from COVID-19 effect. Now, essentially, Section 7 is for the financial creditors to avail of the IBC provisions for insolvency. Section 9 is for operational creditors, and Section 10 is for the corporate debtor itself, which is basically voluntary. Now, COVID-19 related debt excluded from definition of default under Section 312 under IBC. So it's an amendment which changes the definition of default for the purpose of insolvency proceeding. And of course, for MSMEs, a new insolvency framework, which will be notified by an ordinance to be promulgated under Section 240A of IBC. It's still to come in, but this is on the cards. What are the other changes that are being brought in? Central government through Ministry of Corporate Affairs by the notification has increased the minimum default amount for the purpose of provision of Section 4 of IBC.
I think there's a glitch in okay. So I think Advocate Hara has been disconnected due to some network issues. Please, yeah. Thank you for your patience. I'll request him to reconnect.
I'm sorry. Consequently, the minimum threshold for filing application under IBC has been increased from 1 lakh to 1 crore. The other aspect is decriminalization of some of the Companies Act provisions. So this is again a significant step. Um, this, in fact, is coming in by way of a amendment uh, to the Act, um, which is still under consideration and due to come in. Firstly, with respect to technical defaults, which is an area of concern again for debtors, and 7 compoundable offences will be dropped. 5 will be dealt with under other sections, and so on. And it is going to touch upon a significant number of sections. About 65 sections, I'm told, on the Companies Act. However, for today's purpose, we are not focusing on.
Sorry to interrupt you, sir. I think your can you please share your PPT with the audiences? Yeah.
Now, a part of the changes brought into the IBC parallelly, there's been a significant amount of RBI stimulus package which have been brought in. One with respect to rescheduling of payment of term loans. So this has been basically brought about since 27th of March by the 3 packages so far. On 27th, on 17th April, and again in May. So firstly, the rescheduling of payment of term loans and working capital facility. For term loans, there's a grant of moratorium of 3 months on payment of all installments from March 1st to May 31st, which was again subsequently extended by another 3 months in the recent package announced. So that makes it till end of August. This moratorium will apply. Of course, this is on opt-in basis for many banks. However, that's an area which has been handled by individually by the banks. For then again, for working capital facility, which is the crash credit or the overdraft facilities, the lending institution permitted to defer the recovery of the interest applied again up to 31st August. The accumulated accrued interest, of course, is to be recovered immediately after the completion of this period. Then easing of the working capital financing. The lending institutions may recalculate the drawing power by reducing margins and/or by reassessing the working capital cycle, which has been that is, of course, if necessitated on account of economic fallout from COVID-19. So there's a discretion available to the bank. And of course, the classification as special mention account, which is the SMA and the non-performing accounts. So viewers must be familiar with the non-performing asset, which is the 90-day norm for declaration of NPA for substandard accounts. And SMA classification is again another basis of another classification, which is based on prior to declaration of NPA, which has been introduced. So there are 3 SMA 0, SMA 1, and SMA 2. denoting the time period. So SMA 1 is from 0 to 30 days, SMA 1 being 31 to 60 days, and so on, and SMA 2 being 61 to 90 days. So this again is a classification where the banks are required to provide to RBI on a monthly basis, based on which before the account turns NPA, and this comes in primarily for account more than 5 crore. So essentially, there is a greater monitoring being brought in. Now, since the moratorium and deferment or recalculation of drawing power will not be treated as concession or change in terms and conditions of the loan agreement due to financial difficulty of borrower, under paragraph 2 of annex to the RBI prudential framework for regulation of stressed asset, which is basically the prudential framework being followed since June 7, 2019. So consequently, such a measure by itself shall not result in asset class downgrade. So these have been some of the changes brought in from the RBI's side to help the scenario. Now, are these changes enough for the path to recovery from the coronavirus pandemic perspective? The impact of the changes, if you look at it from financial creditor perspective, there's no protection to corporate debtor from the recovery proceedings. So while the NCLT route gets deferred for fresh filing for a year, a lending institution can file recovery proceeding at DRT, may enforce security under SARFAESI Act. So those have been those are anyway available, and whether that that really helps the scenario, given that the corporate debtors are trying to get some benefit from the legislation. Will it dilute the effect of suspension of IBC? So that's a question. So will it dilute the effect of suspension of the IBC, as neither the borrower gets the true relief, and in a bid to declog one court, which is NCLT, it adds burden on the other courts and tribunals. So then there is option of summary suit under Order 37 Rule 2 of CPC for debts without any securities, like a car loan or other loans where there is no substantial security, underlying security. Suspension will cause undue delays. Both financial creditor and operational creditor will have to go through extensive litigation to recover dues. Suspension may not necessarily solve many problems, as it merely puts them back on back burner, because essentially it is deferring by a year and buys time for an inevitable decision which is going to come. So even though a large number of cases will avoid the NCLT for now, greater volumes of IBC cases are likely after suspension is lifted. So it's like I just mentioned, it's just deferring it by a year, so it's all going to pile up. The suspension of Section 10, voluntary insolvency initiated by the corporate debtor, it's been done without providing an adequate relief mechanism for the corporate debtor, really. So it takes away that essential right of corporate debtor. And while the changes are being brought in for the benefit of corporate debtor, it remains to be seen how suspension of Section 10 really helps the case. suspension of insolvency process against personal guarantor to a company is there's no announcement in this regard. So accordingly, if a director or promoter of a company have provided personal guarantees, they may still be taken to NCLT under Part 3 of the IBC. So that remains a question mark. Well, it is. It can be hoped that such changes may be happening in forthcoming months, because with the lifting of lockdown, once the effect of these changes are being felt in the courts. Suspending the IBC to prevent liquidations may prove counterproductive, as firms that could have restructured under IBC will now be pushed into liquidation. So suspending the IBC, whether IBC will now be pushed into liquidation, it may provide counterproductive. So the firms which may not meet fate of liquidation immediately, there will be deterioration in value of as longer the firm continues to remain distressed, the harder will it be to make it viable. So the value of the assets may come down. So by delaying this process by a year, will it really help the creditor is something that remains to be seen. It may be the case in some scenario. Further, amendment to exclude COVID-19 related defaults for initiation of corporate insolvency process seems redundant in the wake of entire suspension for a year. It's not yet clear if the government really intends to continue the benefit of exclusion of the defaults owing to pandemic even after suspension. If it were so, then the suspension of the IBC effect can operate beyond a year as well. So these are some changes which remains to be seen, and obviously after the present ordinance and the changes being affected, as the effect of it will be felt in the next few months, and accordingly changes may be made. When the suspension is lifted, the government will have to make sure that the rights of the creditors are duly taken care of, and the consequence of the suspension shall be dealt with in a proper manner, because that is the essence. If the effect of all these changes have to be made for the proper reason, otherwise it will result defeating the core purpose of the changes which have been brought in. So the fine prints of the specific insolvency resolution framework for MSMEs has not been provided yet, as I said right at the start. So these are things which will come in, and that remains to be seen how the framework will work. Like a pre-pack restructuring or resolution mechanism for MSMEs is desirable. Considering the case that the resolution delays related to IBC and NCLT are persistent, the need for reforms, creating robust outside restructuring process to handle insolvencies is felt. With the IBC suspended, this is an opportune time for implementing these reforms. So, though there is an Amendment Act which is coming in March, a significant amount of reforms yet required, for the robust restructuring process. Now let's look at the impact for operational creditors. Those some of the ones which I mentioned for financial creditors will also apply for operational creditors. However, the suspension will cause undue delays because the operational creditors which will have to go through extensive litigation to cover any due. So in the coming months, one can expect there will be a lot of litigations going forward. Other options of litigation for operational creditors will be summary suit under Order 37 Rule 2, like I mentioned, which is again now it's also important, for a lot of younger lawyers and who may be some of them may be presently on this webinar. What happens? There's a lot of question mark on what happens. With the suspension of IBC proceeding, whether the courts will have enough matters with it. Is it worthwhile having a career in NCLT, IBC, etc.? So that I think firstly there's a lot of action which is going to happen post COVID, and there will be enough of different like summary suits, for instance. One could practice, in civil court, in the arbitration proceedings, which will again, due to various contractual disputes, can emerge. So there's a lot for younger lawyers to look forward to in terms of challenging times in the present economic context to practice as lawyers. Of course, for operational creditors, like I said, summary suit, breach of contract, damage suit, arbitration proceeding, and so on will be the options. The other thing is operational creditor will suffer more. They will be stuck, making them financially overburdened, and henceforth they will not be able to repay their creditors, causing cascading effect, which will continue and distress the financial system even more. So essentially, this is a deeper problem that might emerge because they're going to be overburdened financially, by this delay of 1 year. Some recent judicial pronouncement on retrospective effect. There's a recent judgment of the Chennai NCLT bench on 2nd of June. There's which is essentially which is held that it is prospective and not retrospective. Honorable Bombay High Court considered the present market situation and impact of COVID-19 in rural fair practice wholesale limited versus IDBI trusteeship, where the ad interim protection was provided to plaintiff. Here it is significant that the courts are sensitive to the present conditions, and in fact it was also challenged by way of SLP before Supreme Court, and even the Apex Court refused to interfere with the order. Delhi High Court considered a matter of declaration of NPA in 31st March in matter of Anant Raj versus Yes Bank, again held in favor of borrower in view of March 27 regulation policy. So moratorium was, so even if it was in the scheduled period, status quo ante was maintained. Status quo order was passed, and Bombay High Court also relied on the same judgment while passing orders in other petitions in Sky City Private Limited and Transcon Ironica, etc. So that's in a sense where how it is going to emerge with respect to how the courts are going to look at the present all these changes in IBC as well as various amendments being brought in. So that's all. I'll take questions. Chandrika, back to you.
Thank you so much, sir, for this insightful session. Yes, we do have questions from the audiences. Um, so, sir, as you said about the amendments, so will these amendments have a retrospective effect?
Yeah, like I just mentioned the matter before the Chennai NCLT bench. It is already held that it is going to be prospective and not retrospective. So anything which is prior to 29th of February uh, remains and if it's standard, it will be considered as a standard account. And if it was already the matter is pending before NCLT, so that continues. So it's not uh, it's not going to have an effect of the suspension of 1 year.
Okay. So, sir, the next question is, do you predict any more changes related to IBC or and COVID? Because COVID may stay with us for a longer time.
Well, as I just mentioned, some of these changes are already there for everybody to see. From government, the RBI, everybody is sensitized on the concern of getting the economy back on track, and largely for the issues arising for corporate debtors and the companies, MSMEs and so on. Hence, you can expect lot more changes and amendments to come in, uh, and the effect of the present changes will be felt in the coming months. So just to say that amendments will come in. I mean, like the Companies Act, those changes are anyway pending for the amendment act to be coming in after the parliament nod. But already there are in IBC, in March there was an amendment act. Since there is a 1 year suspension, at least from the perspective of section 7, 9 and 10, um, further changes will come in only after the effect of how this goes on. As regards to other provisions, these are like 241, 242. So other provisions of the IBC still remain open, and further changes will come in.
Okay. Okay, sir. Sir, next question is from Ayushi Suman. She is asking that once the IBC is resumed, even then it can't be guaranteed that the borrowers would have the requisite amount to pay to the creditors. So does that imply that the IBC might be prudently amended once the interim suspension is lifted?
Yes, like I just mentioned earlier in my presentation, that can be a scenario where there's all getting piled up, for the end of the year. Once the suspension gets lifted, so there can be scenario either the suspension gets lifted and you'll have a pile of them, and then grapple with further changes to make to tackle that situation. Or there can be further fine tuning of the present
So, so your voice is breaking.
if it can be categorized in some
Yeah.
way, like some of the other countries. Can you is it better now? So
Yes,
well,
sir.
so these changes, these fine tunings will have to be made
Mhm.
in after the lockdown. Sorry, after the suspension is lifted towards the end of the year.
Well, there is a network issue, I guess.
and during this period, there'll be lot more changes, in terms of process and how the effect of the present changes are being felt by all the stakeholders.
Okay. Sir, now we have a very interesting question over here, which I would like to ask you. Like, uh, do creditors have any other viable framework to follow in case they are adversely affected by these changes?
Sorry, come again. Creditors.
Yeah, so do creditors have any other viable framework to follow in case they are adversely affected by these changes?
Well, for creditors, it's, like I said, it is going to be really tough because, so a part of because NCLT was one very effective tool, for creditors for recoveries. So while the option of DRT and enforcing the security, etc., remains. But given the present situation, the effectiveness of that, as we go forward. In fact, in Bombay, where I come from, uh, there are hardly NCLT. The DRT benches are hardly operational here, and only urgent matters being taken up, etc. So
Mm-hmm.
that there could be challenges uh, for creditors, but then there are options definitely
Yes, sir, I wanted to
available.
ask what are the precautions they can take for the
Uh,
same?
well, precautions in while the credit norms are getting eased, um, one one needs to see the lending norms needs to be robust in these times, because as they will try to provide further restructuring of many accounts and various other such lending which may happen in the next 2 quarters. One has to follow extreme caution in terms of the lending norms to be followed for such lending to happen, because going forward bad loan can become worse, so um, that is something the creditors will need to look at. As far as operational creditor are concerned, they will have many options which were already available, in terms of uh, looking at contractual, if there are contractual clauses, where arbitration clause is there, and one could invoke, or
Mm-hmm.
could look at filing for filing for contractual disputes in any court, so civil court, you could go to. You could look at summary suit, depending on, if there is um, any so there again, you could follow procedure, as far as CCPC is concerned, and take it forward, like I said.
Okay. I think these steps and these precautions would help the creditors in a much better way. So, sir, the next question is asked by Shishir Yadav, which is what is the scope of practice in IBC in tier 2 cities?
Well, already there are many NCLTs being set up in tier two cities, and going forward there are going to be even more. So I see this as a emerging opportunities in tier two cities for practicing advocates to practice, especially who's interested in company law practice, to look at this area. I mean, certainly, tier two cities will have much more grip, going forward, as far as IBC is concerned.
Okay. So, sir, we have a next question from Subhash. He says he's asking that suppose the account is in SMA2 as on 28th Feb 20. If the corporate debtor continues to default for further period and as per the RBI norms, the account is normally classified NPA on 1st May. As per the deferment for 6 months, bank cannot classify the account as NPA up to 31st August. What will happen to this account after 31st of August?
Structuring or any
Sir,
possible.
your voice was not audible in between. Yeah, you can
Okay.
go ahead now.
What I mentioned was from now till 31st of August, there is opportunity for restructuring of the account and possible and possible funding further or restructuring of the present dates, etc. But if that does not work, it is after that, it can still be since it is already SMA2. It can be declared NPA after post that period, and of course, I mean, IBC route will be closed till for a year, but other routes for recoveries will be available for the creditor.
Okay. So, sir, as you mentioned about these sections in your PPT, Shivam Sharma has asked the question. Since the functioning of section 7, 9, 10 of IBC has been suspended for 1 year and at the same time threshold limit has been extended to 1 crore. Can one say that change in the threshold limit will actually come into force after 1 year? That is when these
Yes,
sections
I
will
didn't.
resume.
I'm sorry, I didn't hear the last part. Can these with the threshold increasing what?
Yeah. Can one say that change in the threshold limit will actually come into force after 1 year? That is when these sections will resume.
Well, yes, effectively, the change in minimum threshold is redundant. With the fresh suspension of the IBC 7 provisions. Change
Sir,
for the
sir,
betterment,
you were
because
not audible in
the
between. So
courts have
can
been.
you, yeah, can you
Yeah, I'll try to repeat. So
repeat? Yeah.
essentially, yeah. So it renders the threshold, the increase in threshold limit, is virtually is redundant, since there is already a suspension of the fresh section 7, section 9 IBC provisions. Uh, However, these are welcome changes which have been pending to be brought in since some time, and are going to be effective going forward in the courts, because the courts have been really with these. So this is, I mean, so your question was that whether this really helps in the present
Yeah.
situation. It may not, but going forward it will. So it is a change for the good.
Yeah. Sir, the next question that we have is from Kavya Maheshwari. What will be the effect of recent amendments on the entities going under the insolvency proceedings? I think very good question and practical too.
Again, I lost you in the middle. I'm sorry, Chandrika. Can you repeat that?
I'll repeat the question, sir. what will be the effect of the recent amendments on the entities going under the insolvency proceeding?
Yeah, well, so if she meant the entities which have already gone in for insolvency suspension,
Sir, you are not audible.
but as other amendments, they will.
Sorry, sir. Can you please repeat your answer?
So, because with the suspension, if she, I think it is showing as unstable. Let me see if I can get. Am I audible?
Yes, sir, but I think there is a network issue.
Yeah, it just showed some will not get affected with the suspension.
Sir, I think there is a technical issue. I mean, either it is, I think it's network issue.
Because those are already.
You're not audible, sir.
I'm sorry, I think I dropped out. Am I audible now?
Yes, sir.
Yeah. So with respect to the present, the existing entities which are undergoing liquidation or are in the process of CIPR or pending for hearing and do not fall under the period, which is prior to 29th. That of course it will depend on the circumstances. The courts, like I mentioned, some of the in some of the matters, the court has been cognizant. Even during specified period, they have come to the rescue of. But that depends on the situation. That is as far as the corporate debtor is concerned. With respect to financial creditor, it is clear. You know, it is the fresh filings are suspended for a year, and they can avail the other proceedings.
Okay. Sir, a student has asked, what skills should we have and what subjects should we master to expect a robust practice in the NCLT and related fields?
Well, it is for aspiring, and budding advocates who are wanting to practice in this area. There's a lot of opportunity in this because there's a lot of consolidation of this thing. It's just that one needs to be abreast of all the changes which is happening because it is happening at quite a rapid pace. This IBC is also a fairly young legislation. Which has been brought in 2016, and already there are so many amendments which have been brought in subsequently. So one needs to be abreast of all the changes happening in this field. This is a very, very dynamic field, and a lot of interrelation of various law and that's what makes the subject and the area interesting. When you look at the liquidation laws or the insolvency laws vis-a-vis the recovery laws, or for that matter in SEBI and SAT. There are a lot of interrelation, and we as practicing advocates see these lot of these matters can have multiple legs in different forums. So one needs to be abreast of all the related legislations, and well, there is a great scope. I mean, like any other area, but there's a great scope definitely in corporate law practice.
Uh, since there is a time constraint, I would like to ask the last question for the session, and further questions would be mailed to you, sir, so that
Sure,
you
sure,
can answer and share it to the persons who were asking the questions.
sure. That's
So
fine.
the last question for the session is, what will be the best course of action or action for the banks in the regime of the new code?
Um, well, it's like I said, the subject. That's why I chose the subject for creditors, because it underscores the challenges for the banks, and the tricky situation for the bank, um, uh, as much for the corporate debtors. Everybody is trying to come to the rescue of the economy, trying to bolster it by giving all the impetus to SMEs and so on. But with respect to the bank, um, you know, um, uh, one has to be careful in terms of in terms of how to lend further. So all the lending norms needs to be scrupulously followed. And I expect a lot more, in coming months from RBI in this regard. Uh, at the same time, there is opportunity for lending, and since a lot of companies would be looking at revival, and looking at for fresh loans. So well, I mean, so I see potential. At the same time, one needs to be very circumspect with respect to recoveries of the existing ones. As I said, um, I mean, the NCLT is still open in all the forums, so it continues as is. With respect to, it's just that the fresh filings will get stalled for a year in NCLT. The rest, everything else follows. So um, I mean, it's like a crystal ball gazing as to my guess is like anybody else is here, as to how it will affect going forward. We'll have to wait and see. I think we'll have to take the initial 3 months and then see how it goes going forward.
Yes, indeed, sir. So with this, I think, yeah. So thank you so much, sir. This was and one of the insightful session on insolvency and bankruptcy. So on the ending note, sir, can you just brief us about the difference between this insolvency and bankruptcy in like in a simplest way? Okay. Am I audible, sir? Sorry for the inconvenience. Yeah. Thank you for the patient audience. Yes, sir.
All right. Yeah, thank you. Thanks for having me. Love the interaction. Look forward to more interactions in future.
Thank you so much, sir. And we should not forget that you are based from Maharashtra, and the current situation in Maharashtra is not in favor. And then also you were so supportive, and you took this as a challenge to manage this webinar. And thank you so much for your lovely presence and Thank you for sharing all the knowledge on this particular topic, sir. And I thank you and on the behalf of our organization organizers, that is Lawyers and Lawyers Club of India. And thank you audiences for your cooperation and for lovely questions. And also thank you from the audiences, sir. They have commented
Thank you to the
beautifully. Yeah,
audience.
for
Really,
the they have actually commented that it was a very good and informative session. Yeah, thank you so much. Anything else you would like to say, sir?
no, I'm good. So if there is further questions, you can forward it to me.
Sure,
I'll
sir.
respond to them. And look forward for more interaction. This is
Definitely, sir. Yeah.
there's going to be challenging times ahead for economy. So there's a lot more such sessions will be required because things are changing very dynamically in this space. So I think we'll have to look out for more as it comes, from any side, regulators,
Okay, I end this session over here. Thank you so much, sir, for your presence, and thank you all for joining this session. Bye.